Hello, guys, and welcome to Study Time Anytime, the YouTube channel, the channel especially made for the benefit of the students. Continuing the series of important Canadian case laws, we'll start from our fifth video from uh, from the 16th important case law, that is the discrimination based on sexual orientation. Delvin Wrend worked as laboratory coordinator at a college in Edmonton, Alberta. After he disclosed that he was homosexual, Delvin Wrend was fired from his position. His sexual orientation did not comply with the college's policy on homosexuality. Wrend wanted to make a complaint with the Alberta Human Rights Commission that his employer had discriminated against him. However, Alberta's human rights legislation did not include sexual orientation as a prohibited ground of discrimination. So it's important here. Alberta's human rights legislation did not include sexual orientation as a prohibited ground of discrimination. Wrend argued that failing to include the sexual orientation as a prohibited ground of discrimination infringed his equality rights. The Supreme Court agreed and confirmed that sexual orientation is a prohibited ground of discrimination under the Charter, even though it is not specifically listed. The court read in the words sexual orientation into the list of prohibited grounds in the Alberta law. This case law is important for many different reasons, including its discussion of how even human rights laws may violate equality rights when they fail to protect specific groups of individuals who have historically been discriminated against. So the case law is Wrend versus Alberta 1998, 1 SCR 493. 17th is equality rights for same-sex partners. M sought spousal support under the Family Law Act. Now M here is the petitioner. M sought spousal support under the Family Law Act after her same-sex relationship ended. The Act defined a spouse as a person who is legally married or an unmarried man or woman who has lived with a member of the opposite sex for at least 3 years. M claimed that the act violated her equality rights since it treated opposite-sex unmarried couples differently than same-sex unmarried couples. The Supreme Court found that the act discriminated against people in the same-sex relationships. The act implied that their relationships were less valuable, less worthy of recognition, and less worthy of legal protection than the relationships of opposite-sex couples. This denial of the people's equality and dignity in the eyes of law is exactly what the Charter was meant to protect against. The Supreme Court observed that this denial of the people's equality and dignity is exactly what Charter was meant to protect against. Because of this landmark case, legislation that discriminated against same-sex couples was changed across Canada. This case helped pave the way for full marriage equality to be achieved across Canada in 2005. M versus H 1999 2 SCR 3. Moving forward The next case law is the right to a state funded lawyer when the government seeks to remove a child from his or her parents' custody. The New Brunswick Minister of Health and Community Services was granted custody of Ms. G's three children for 6 month period. The minister wanted to extend the custody order for another 6 months. The children's mother wanted to go to court to argue against the custody order extension but could not afford to hire a lawyer. She applied for legal aid under New Brunswick Domestic Legal Aid Program but was denied because at the time the program did not cover the cost of lawyers in the custody cases. Ms. G challenged the provincial legal aid program, arguing that it violated her right to security of the person because the hearing would not be fair if she did not have legal representative. The Supreme Court agreed, finding that when the government removes a child from a parent, this causes so much distress, stigma, and rupture of the parent child bond that it interferes with the parent's security of the person. This means that charter guarantees the parent a right to a fair hearing in such cases, which may require legal representation for the parent where the case involves complicated facts or legal argument and where the parent cannot afford a lawyer, the government must pay for the parent's legal representation. This case ensured that parents seeking to challenge a government agency's removal of a child from their care would be able to meaningfully participate in the custody hearing. It also confirmed that the Charter's protection of the right to life, liberty, and security of the person is not limited to purely criminal law cases. So, this is a very important case. New Brunswick, Minister of Health and Community Service versus G, 1999 3 SCR 46. Next case law is freedom, speech, and equality of the LGBTQ2 community. Little Sisters was a specialized bookstore that sold books primarily to the gay and lesbian community. The bookstore imported most of its material from the United States. Custom officials classified the books and other materials as obscene, which prevented the shipments from entering Canada. Under the customs regime, businesses and individuals in Canada were prohibited from importing obscene materials into Canada. Little Sisters challenged the customs rules, arguing that the regime violated freedom of expression and equality rights of the LGBTQ2 community. The Supreme Court concluded that the customs regime did limit freedom of expression, but that most of the law could be justified as a reasonable limit on this right. However, the court found that the way that custom officials were applying the law violated the equality rights of the customers of Little Sisters bookstore because officials were applying a discriminatory standard to their materials compared to those aimed at heterosexual audience. This case held paved the way for further recognition of the rights of sexual minorities in Canada and also confirmed that the freedom of expression protects the right to receive materials like books. The case also highlighted that both laws and the actions of all government officials must respect the Charter. So the case title is Little Sisters Book and Art Emporium versus Canada Minister of Justice. Case here is 2002 SCR 1120. So these are some more important case laws related to the constitutional law and the charter of the Canada. Thank you very much. We'll continue the series. Please stay tuned for free education related to the Canadian law and other laws of the countries. Thank you very much. God bless you all.